name is Rehan Abiratna. I'm an associate professor of law at the Chinese University of Hong Kong and the executive director of our Center for Comparative and Transnational Law.
My name is Mara Malagodi. I'm an assistant professor at the Faculty of Law at the Chinese University of Hong Kong.
We'll begin by introducing Justice Bokhary and then ask him a few questions about judgment writing and the factors that influence him when he writes judgments. So let me begin with an introduction. Kemal Bokhary was called to the bar in 1970 by the Honorable Society of the Middle Temple, of which he is now an honorary bencher. In 1983, he was appointed a Queen's Counsel. He practiced mainly in commercial law before the Hong Kong courts and the Judicial Committee of the Privy Council until 1989. In that year, he was appointed a High Court judge, and he has been on the judiciary ever since. He was elevated to the Court of Appeal in 1993, and in 1997, he became one of the founding justices of the Court of Final Appeal of Hong Kong. He was a permanent judge of that court from 1997 to 2012. Since then, he has been, as he is now, a non-permanent judge of the Court of Final Appeal. He holds 2 honorary doctorates of law and is an honorary professor of the Faculty of Law of the University of Hong Kong, as well as our institution, the Chinese University of Hong Kong. The Hong Kong government has awarded him the Grand Bohemia Medal, and he is also an accomplished author. He's the author of 7 books, most recently The Constitutional Crocodile, co-authored with his grandson. So welcome, Justice Bokhary. Thank you very much for doing this.
Thank you very much.
I would like to start with asking you a few questions about judgment writing. And first of all, what is your approach to judgment writing?
Well, when writing a judgment, judges must set out the facts, the issues, the arguments, and the reasoned conclusions. They should endeavor to do that with clarity and concision. And I think it's important, and sometimes forgotten, that they should do so with sensitivity towards those that they are going to decide against, and anyone who they cannot avoid criticizing. That is an aspect of judgment writing which I think is sometimes forgotten, and it ought not to be forgotten. I suppose there are times when the judgment is likely to create a precedent. And if that is so, then the objective must be no more ambitious than providing a reliable foundation on which the law can be further developed. The one sure way to get the law wrong is to imagine that you are saying the last word on it. There's no such thing. It's a continuing process. The law is under constant development. And every time you give a judgment of any value, you are only building one brick into this temple of learning that we call the law. And it seems to me that it's very important to bear in mind that what contribution you make in that regard is built upon what other people have done in the past. And if further developments take place with your judgment in mind, then they are developing it with your views taken into account, just as you had taken other people's views into account when you arrived at that conclusion. I would have thought that's about it.
Thank you so much. Has your approach to judgment writing changed over time?
Well, subconsciously it may have. consciously, I don't think it has changed over time, except to the extent that the particular requirements of judgments are not identical as between those at first instance, those on intermediate appeal, and those delivered in a court of last resort. So since I have moved from one court to another, my career has consisted of a series of demotions. I used to have an entire court to myself as a high court judge. I was then put in the Court of Appeal where I had to share it with 2 other judges. And now I've been brought so low that I have to share it with 4 other judges. So I'm not sure what a judge would say if that judge had spent the whole of their career, or at least the whole of their career up to the time that you asked that question, would say. But I have, made these, have undergone these demotions, and therefore those changes have been forced upon me.
And thank you so much. Demotions, well. And I have a follow-up question on this. Does your approach to judgment writing change depending on the type of case that is before you? So whether that is a civil, criminal, constitutional case, or any other area of law?
Well, Mara, I think that there are some basic requirements that don't change, but there are some things which do change from case to case. If you are giving a judgment on commercial law or revenue law, it's highly likely that the litigant who's going to be affected, or the party who is going to be affected in their dealings, or how they structured their dealings, will be themselves well advised by lawyers of high quality. And you don't imagine them reading the judgment for themselves quite as much. Although if they are very experienced businessmen, they may be able to follow it. And of course, if the judgment is read by an accountant, and never mind, he's not a lawyer, he's going to be able to follow it anyway. So you subconsciously, if not otherwise, have some reflection upon the expertise of the likely reader. If you are writing a constitutional judgment, then I think you have to bear in mind that it might have a very wide readership among the general public. If I recall what I read about it, it was said that when the United States Supreme Court was about to hand down its judgment in the great desegregation case of Brown Board of Education, Chief Justice Warren said that he wanted one judgment. He wanted it intelligible to any reasonably educated reader. And he wanted it short enough for every major American newspaper to carry it in its entirety the following day. And I think that's what happened. So those are some of the special requirements for constitutional judgments. When you're writing a judgment in an appellate judgment in a criminal case, I think you have to bear in mind that some of these propositions that you lay down are going to have to be conveyed by a judge to a jury. And therefore, you want to make it fairly easy. You can deal with all the more difficult stuff, but at the end of the day, you really ought to say, well, the best way to convey this to a jury is to say either precisely this or something to the same effect. that make it easy. I remember when I was sitting in the Court of Appeals a long time ago, we were going to lay down a judgment on something which would have to be conveyed to the jury. And I went and saw a number of High Court judges and said, look, we said this, would you know how to explain it? And they said, yes. Would you have any difficulty with it? No. So you go ahead. So I think you have to look at the consumer, and you really have to be sort of market driven rather than product driven. You don't want to say, come here, gape in admiration at my learning. These are working tools of the law in action. So if you want people to gape in admiration at your work, then do an oil painting.
Thank you so much. And following on these points, do you think that a trial judge should adopt a different approach to an appellate judge in judgment writing?
Well, some of the approach between first instance judges and appellate judges was subject to an attempt by Lord Asquith to capture when he said that a trial judge should be quick, courteous, and wrong, which was not to say that the Court of Appeal should be slow, rude, and right, because that would be to usurp the function of the House of Lords. But leaving aside all that sort of clever stuff, the truth of the matter is the judge at first instance is very often concerned with finding the facts, and therefore the judgment has to set out the evidence and the arguments on the facts and the conclusions which he reached and why. A appellate court is not involved in finding facts on a first-hand basis. They're basically either coming to conclusions of fact based on inferences on the primary facts found by the judge, or perhaps overturning the findings in very exceptional circumstances, but not really making a fresh start. Now, as far as the law is concerned, you say, well, right, that's for the facts. As far as the law is concerned, well, the trial judge might sometimes think that the law ought to be A, but there is a precedent on intermediate appeal saying the law is B. And he might, in the event of the being appeal, he shouldn't say, well, the Court of Appeal is very silly and they said B, I should say A. But you might say, well, I'm bound by this authority. It cannot be reconsidered by me. It might be reconsidered on appeal, and then set out some of the arguments on it. I remember an instance in which my wife later became a High Court judge when she was sitting as master, had to deal with whether or not something was arguable and therefore affected the title. And she was clearly of the opinion that the judgment given by Mr. Justice Godfrey was right and would render the point unarguable. But there was a judgment by another High Court judge who really essentially was a criminal lawyer, but he had given a judgment on it. And I don't think she felt entitled to say, look, Godfrey is a very great chancery lawyer, and this chap is a criminal lawyer, forget about him. She simply said that she felt that sitting as a master, she had to recognize the point was arguable, given that there were two different views expressed. But if it went on further appeal, then a choice might be made for one rather than the other. And I see she might have given some indication, but you don't have to give much indication anyway. So sometimes the trial judge has that. Now, an intermediate appellate court might also be bound by authority. The final appellate court is not bound by any authority at all. Therefore, it's often said that you should address a someone said that you should address a court of last resort. He was talking about the House of Lords, but it could be any, rather like they were a common jury, because they're not bound by anything. You can convince them something is good. And that's not quite right, because the law, I mean, involves a certain amount of continuity. And therefore, it's not as if the judges are writing on a clean slate. But how the law develops at its frontiers is open to the court of last resort in a way that's not open to the intermediate appellate court, and still less to the court of first instance. So again, these things probably affect approaches to decision-making and judgment writing. For example, a dissent in a court of intermediate appeal is directed to the final court. A dissent in a court of last resort is what Chief Justice Hughes said was an appeal to the brooding spirit of law, reflecting the hope of the dissentient that some future decision might correct the error into which he felt the majority had been portrayed in that particular instance. So it is different. The audience is different for a start. And but it is common to emphasize the differences since one's asking about them. One must also remember how much of it doesn't change, how much of it's the same. Clarity, concision, and hopefully giving the judgment without undue delay.
Thank you very much, Mr. Justice Bokhary. I'll pass on to Rayan, who's going to ask you some questions about factors influencing judgments.
Yeah, thank you, Justice Bokhary. Really, really insightful, I think. Especially on I particularly like the point about the intermediate dissenting judge having a very specific audience. It's an audience of 5, I suppose, right? The panel that's going to sit at the higher on the Court of Final Appeals.
Well, he only has to influence 3 of them.
That's right. That's right. 3 out of 5. So as Mara said, I'd like to ask you about some other factors that might influence the judgment, both internal and external. So let me start with the internal factors, beginning with the submissions you receive. So, I imagine at the Court of Final Appeal, you receive written submissions and you also hear an oral argument. And I was wondering the degree to which each of those influence you. I mean, is it really based on the written submissions that you usually come to a decision, or can a lawyer convince you with a good oral argument?
Well, he could even talk you out of a decision which you were to give in his favor if he's not careful. But I have never, ever sat in court and not been to some extent influenced by the oral argument. If not as to result, then at least as to reasoning. I'm not saying it can't be. Maybe you would say the chap's talking about solid nonsense and you pay no attention to him. You notice I said chap. Normally I do not like to be gender specific, but if you're being critical, you can confine it to the chaps. Anyway, so the oral argument is very important. And you have to remember that the judge has an opportunity to ask questions as well and draw out the argument. So when the judge is reading the written submissions, she is just dealing with what has been placed before. But when they are receiving oral argument, then they can draw out the argument and shape it. And therefore, the oral argument has got a certain degree of flexibility in it. And it can be shaped according to the needs as the judge perceives. And quite honestly, I mean, look, as far as judicial inventions are concerned, I'm going to give a talk on advocacy soon, and I'm going to have to say it, that judicial interventions have to be dealt with constructively by counsel, whether they like it or not. But of course, some of them like it, and some of the judges wish the judge would shut up. Whether you welcome the opportunity to deal with it, or you wish the fellow would shut up, you've got to deal with it. And quite honestly, I mean, supposing you were appearing false in the Court of Final Appeal and we were giving you a hard time, well, you're still alive. But what if we just kept quiet? In other words, waiting for you to finish so we can decide against you. So, you know, while they're kicking you, you're still alive. If they stop kicking you, it means that they think you're dead anyway. So, you know, the oral argument is important, and counsel should take full advantage of it.
Great. So I wanted to ask also about how much you're influenced by your colleagues. Is there a practice of circulating drafts among your colleagues at the Court of Final Appeal? Or again, does it depend on the case? Perhaps in a particularly important decision or a constitutional case, do you seek input from colleagues, or is that not something that's done?
Well, see, what happens is that before the case comes on, you may well discuss it. In fact, today I was back in the court attending a judgment conference because you don't have the judgment conference to decide the case, but you have a judgment conference to see what particular points counsel might be directed to expand upon, and so on and so forth. So it's all directed to what happens when there is the oral hearing. But of course, some tentative thoughts are formed and exchanged, sometimes by a formal judgment conference, or sometimes just when you bump into him in the corridor and say, oh, what do you think about that one? Or have you had a chance to read the printed case, and so on and so forth? And somebody might say, yeah, well, that's true, but there is something else about it, or maybe he hasn't noticed this decision or that particular statutory provision. So that kind of thing goes on. And then during the hearing, there are breaks. We don't sit from 24 hours a day. There's a mid-morning break, there's a lunch break, and then overnight break, and there are discussions then. So that all happens. And when it comes to writing the judgment, one might say, well, we all have to think about it, see what happens, and then drafts are circulated. Or people might say, well, we all think that this is the likely result, and then would you care to write it, you see? And then you would write it, and then you would circulate the draft, and we would, give our input. And some judges were very helpful in their input. I think Lord Millett, in particular, was very good about making a lot of suggestions. He was quite happy to let you have it. He was going to give a concurring judgment. He'd put it to you in a very nice way, and so on and so forth. And if you adopted it, fine. So he was very helpful. Most of them are. Of course, if it's somebody like Lord Nichols of Birkenhead, I'm highly likely to agree with every word he says anyway. He was by far the best judge who ever sat in the Court of Final Appeal, by far, bar none, great as the other ones were. And let's face it, I mean, although everybody is good, some are better than others. And with some judges, you are more apt to want to suggest to them changes and so on and so forth. There was one occasion when Lenny Hoffman wrote a judgment, which I thought was quite rude. And he said that Mr. So-and-so said ABC. That is right, but I don't know why he thinks it helped him. So I went to him, I said, this guy's a good friend of mine. Do you mind saying Mr. So-and-so said A, B, and C? That is right, but it doesn't help him. He made that change. There have been occasions when the judge has been sort of I thought maybe overly critical of counsel or dismissive of their argument. And I have suggested a more gentle way of putting it. But if they don't agree to it, you can't write a dissent to say, I agree with everything you say except the rude bits, and set them out. So you just say, well, I arrive at the same conclusion. I think I will briefly indicate my reasons. And then you say practically the same thing, minus the rudeness. This kind of thing happens. And the most unfortunate, let me have a cup of tea. The most unfortunate thing that ever happened in the history of the Court of Final Appeal was some change to a draft of mine made by Andrew Lee. Because an argument was presented to us by Mr. John Griffiths, QC, who usually wins, but not always, nobody can always win. And on this occasion, we had to dismiss the appeal, you see. And I concurred by simply saying that Mr. John Griffiths, QC, has ably argued a difficult brief, but for the reasons set out in the judgment, so and so, I can't remember who it was. I agree that the appeal must be dismissed, which is a very courteous thing to say and very charming and very typical of the nice sort of chap that I am. Unfortunately, there was when I dictated to my secretary, rather lazy, rather than tapping it out myself, she heard wrong. And I didn't say that he had ably argued a difficult brief. I said he'd ably argued a different brief, which made it sound like he was drunk in court. And that was very unfortunate. But what was even more unfortunate was that Andrew Lee spotted it. And the most unfortunate thing was I agreed to change it. I wish I hadn't. It would be such fun to leave it in. I mean, he couldn't sue me. First of all, he's a good friend of mine, so he wouldn't sue me. And secondly, if he sued me, I was protected by absolute privilege anyway. So that was a very unfortunate bit of input from a colleague, but usually it's quite helpful, not always as disastrous as that. I hope John Griffiths doesn't get around to watching this.
That's a great story. Could I move on to asking you a little bit about the sources used in opinions at the Court of Final Appeal? So for folks sitting outside of Hong Kong, I think it's maybe worth saying that the Hong Kong Basic Law explicitly permits judges to cite foreign sources, especially from other common law jurisdictions. And the Court of Final Appeal is known as a comparative court, one that sort of cites a lot of foreign sources. And so I was going to ask you, Justice Bokhary, to what degree did you do that in your judgments? Are there particular courts that you look to more than others?
I think I probably did it more than most of the judges, but we all do it to a greater or less extent. I think in the constitutional field, the decisions of the United States Supreme Court were very valuable because they have such a long history of constitutional jurisprudence. And therefore, one would probably cite them with some degree of frequency. I suppose so much of Hong Kong's common law is based on English law. What Mr. Just Story called, he referred to the common law of England as the grand reservoir of all our jurisprudence. So sometimes when you're citing a decision of the House of Lords, you don't really know whether you're really citing a foreign judgment as such. I mean, it's so much part of our legal DNA, especially when it comes to commercial law and principles of tort and things of this sort. One looks to the jurisprudence of international tribunals and transnational tribunals, especially in the field of human rights, because, I mean, human rights really was developed by the international, well, the Permanent Court of International Justice and International Court of Justice, and by scholars of international law in advance of municipal judges or scholars. So you look at their jurisprudence. So that goes on. I have quite often cited decisions of the Bundesverfassungsgericht, the German Constitutional Court. One of our secretaries once said, it's a very long name, Bundesverfassungsgericht. And I said, well, actually, it's not as long as the Hong Kong Court of Final Appeal, or worse, the Court of Final Appeal of Hong Kong. I said, it's just that they put it all in one word. So they have, I found, not because I think it's particularly fun to cite any particular judgment, but I have very often found valuable insights in their judgments. And if you look at the extent to which they have kept kept Germany out of trouble with the European Court of Human Rights, they're probably quite a good constitutional court. I mean, some countries don't end up, some European countries don't end up in Strasbourg quite so much, but that may be because the legal profession and the legal academy in their jurisdiction is not sophisticated enough to draw attention to these. But you can't say the German academy or the German academics, the German practitioners are not astute. And therefore they would certainly take it there if there was something to take, but they tend to get it right in Karlsruhe. No need to go to Strasbourg. So that is part of their pedigree. And then as far as sources are concerned, I often consult academic sources, local and foreign. Sometimes when I've always said that Yash Guy was our leading constitutional scholar, and I don't even know whether he's a local academic or foreign source now. But anyway, I like to cite him. In fact, last time I saw Yash, I was saying, well, I call you the Hong Kong's leading constitutional scholar. I said that those people who speak the Urdu language would probably think that I don't think much of you because the language is so flowery. They would think that I should say that you are the jade garden of jurisprudence. And if I didn't say that, they wouldn't think much of you, and we laughed about that. So you look at foreign sources. Shall I tell you a funny story? Lord Cook, another very great judge, told me that he went to have lunch with Denning. And he asked Denning, of all the great figures of the past, who would you most like to have sat with? And he thought he might say Mansfield and Cook and Mansfield because they were supporters of Denning's coat of arms. But Denning found the question a bit strange, and he seemed to suspect to think that, why was it necessary to sit with anybody? It's more difficult to do justice if you're sitting with other people because you have to overcome them. And much better to do justice, But anyway, Robin Cook is not the sort of chap who's put off easily. So he pressed him, and Denning, getting fed up or perhaps feeling that the obligations of a host required him to answer the question, said, well, I suppose I would have liked to sit with Geoffrey Cheshire. So there it was. He named an academic. And it's very interesting because Denning often sort of was influenced by Cheshire, and Cheshire was forever citing Denning's judgments. So this was going on behind the scenes, but it's very telling that he said that. So you might have to take a drop in income and go on the bench.
Thank you so much, Justice Bokhary. I think we'll end the interview there. Really, really appreciate your time and these insights, the humor. Really wonderful. Thank you.
Thank you so much.
Yeah, it was a great pleasure.